Thanks very much. I will speak a little bit about the problems of criminalization. As the professor on the panel, I hope you'll excuse me if I'm impractical and theoretical about things, but I'd like to try to address some of the effects that current law and law enforcement policies are having on the behavior of business and business people, and perhaps I can talk a little bit about some of the consequences that can impact legal matters. I'm going to suggest that current law and policy is both counterproductive and it incentivizes businesses and business people to act in ethically questionable ways. So let me begin with the law and sort of do a little bit of review. Under current federal and most state law, corporations are subject to criminal punishment on a respondeat superior theory of liability. So corporations are liable for the actions of their employees, criminally liable for the actions of their employees that are taken within the scope of their employment and are intended to benefit the corporation. This is the case regardless of whether the employee's actions were violations of corporate policy. This is the case regardless of whether the employees had been given explicit instructions not to engage in the conduct. And this is the case regardless of whether the corporation has the most pristine corporate culture and has undertaken the most vigorous efforts to prevent employee wrongdoing. Now, corporations are strictly liable, strictly criminally liable, for the actions of their employees. And so why is this the case? There's a justification for respondeat superior liability in assigning tort liability. Employees are often the type of people who are judgment-proof, and they can't be deterred from engaging in risky behavior that will increase their pay or get them a promotion by fear of civil liability. So respondeat superior liability creates an incentive for employers to deter that type of conduct by their employees. But no employee is criminally judgment-proof. All are subject to the threat of criminal punishment or criminal activity. So why do we punish their corporate employer for their actions? Now, sometimes the response is corporations are legal persons. As legal persons, they should be subject to the same law as natural persons. But that response is actually a non sequitur, because legal personhood doesn't imply criminal responsibility. Infants, incompetent people, the insane are legal persons, but they're not criminally responsible. Criminal law is about punishment. To be criminally responsible, a corporation must be the type of thing that can be deserving of punishment. So does subjecting corporations to the criminal sanction advance any of the legitimate purposes of punishment? That should be the basic question. All right, what are the purposes of punishment? Typical purposes offered are usually retribution, deterrence, or rehabilitation. Retribution can only be imposed on those who have acted in a blameworthy way. Retribution clearly justifies punishing those who commit the offense. But how can it justify punishing the corporation? Corporations can't be imprisoned, they can only be fined. And the defining characteristic of the modern corporation is the separation of ownership and control. When a corporation is fined, it's the owners, the shareholders, who pay the fine. The shareholders have no control over the actions of the corporate employees who commit the offense. So inflicting punishment on a corporation's shareholders or on innocent employees who may lose their jobs if the corporation suffers a reverse is punishing the innocent. And punishing the innocent, punishing those who are innocent of wrongdoing can't be justified on retributivist grounds. All right, so what about deterrence? A major purpose of criminal law, of course, is to deter wrongdoing, but not by punishing the innocent. We could very effectively deter wrongdoing. For instance, we could perhaps greatly reduce crime by teenagers if we punish their parents for all of the offenses of the children. But that's typically not a justification for punishment. Deterrence is a justification for criminal punishment when what you're doing is punishing those who engage in wrongdoing in order to deter others from similar activities. It doesn't refer to punishing the innocent to pressure the innocent, so to punish the innocent to pressure them into curtailing the activities of their fellow citizens. Rehabilitation is a justification for punishment. I've been on several of these panels, and prosecutors frequently argue that corporate punishment is justified on the grounds of rehabilitation because the fear of prosecution can make business people behave better. But think about the word rehabilitation. It refers to changing the behavior of wrongdoers into socially acceptable conduct. To rehabilitate, you first have to have someone whose conduct is unacceptable. Rehabilitating those who are innocent of wrongdoing is called depriving them of their liberty. This was familiar in the Soviet Union or Maoist China, where people whose conduct was unacceptable to the government were sent to psychiatric hospitals or re-education camps. These justifications can justify punishing the people who commit the offense. It can't justify vicarious liability that's imposed on those who haven't committed the offense. So what does justify corporate criminal punishment? Prosecutors will tell you that they have no interest in punishing the innocent, and that's true. They just want corporations to cooperate with them in combating business crime. And I take them at their word. I'm sure that that's what the driving force is. So the purpose, if we take them at their word, the purpose of criminal punishment is to reduce the incidence of white-collar criminal offenses. If that's the case, if that's really the purpose of punishing corporations, then I'm going to contend that present law enforcement policy is terribly misguided. A great deal of research has been done on how to reduce illegal and unethical conduct in the business environment. And I mean a great deal of research over decades. This is pretty fairly established. There are two basic approaches to reducing employee misconduct. They're called the command and control approach and the procedural justice approach. The command and control approach involves the intensive monitoring of employee conduct, threats of sanctions for wrongdoing, enforced cooperation, these kind of procedures. And the evidence shows that adopting such measures can reduce law breaking by employees, but not very much. The procedural justice approach essentially requires corporations and business people to treat their employees with respect, and this involves not constantly monitoring their activities. You want to not make them feel as though they're being spied upon. You want to reward trustworthy behavior with trust. You want to trust your employees. You have to rigorously honor all promises or commitments that you make. It involves undertaking very serious self-assessment to discover potential wrongdoing and rigorously adhering to programs of organizational justice, which usually involves you want to take swift action against those whose wrongdoing has been established by fair procedures, and you want to reward those who behave ethically. And the evidence shows that this approach can significantly reduce law breaking by employees. Apparently, these measures work by aligning the employee's personal values with the corporation's values, and it increases employees' commitment to follow the corporation's rules. But more significantly, the way it works is when employees feel they're being treated fairly by a corporation, they're more willing to come forward and inform management about those within the organization who are breaking the rules. An offense against the corporation is felt as an offense against oneself and not as somebody else's problem. So this is actually the most effective way of reducing employee wrongdoing. The problem is that current law enforcement policy right now is embodied in the organizational sentencing guidelines and in the Thompson Memorandum, which governs Department of Justice policy. And this policy brings nearly irresistible pressure on corporations to do two things. One is to adopt compliance programs which intensely monitor the conduct of corporate employees, and the other is to cooperate with criminal investigations. Now, cooperating with criminal investigations sounds fine until you look at what cooperation means. The first thing required to be cooperating is a corporation must accept responsibility for wrongdoing. But corporations can act only through their employees. So if a corporation accepts responsibility for wrongdoing, what it's saying is its employees have engaged in wrongdoing. So cooperation requires right off the bat that a corporation accuse its employees of wrongdoing or presume that they're guilty. Once you presume that the employees are culpable, cooperation requires a refusal to support culpable employees. What does this mean? Well, this means you should not advance their attorney's fees. It means that if they don't cooperate, they should be sanctioned. Usually that means fired. It means you should refuse to enter into joint defense agreements with them. Cooperation also requires the disclosure of, quote, all pertinent information. Now, a big issue with this is that it often requires the waiver of attorney-client and work product privilege, and I'm sure others are going to talk about this, so I'll focus on something else. I mean, it requires corporations to turn over the results of all internal investigations and disclose confidential information. Attorneys know about attorney-client privilege, but the main way in which corporations get information about wrongdoing is they typically set up these confidential employee hotlines in which they promise employees, if you use this mechanism of bringing information to management's attention, we'll keep the information confidential. And this is the information that is then turned over to the prosecution. What this policy mandates is the command and control approach to reducing employee wrongdoing. By pressuring corporations to become deputy prosecutorial agents, this approach places the corporation and the employees in an adversarial relationship. Current policy punishes those corporations who try to adopt the more effective procedural justice approach to reducing criminal activity. Right, that requires investing trust in the employees, and not spying on them all the time. Trusting your employees, not monitoring, produces inadequate monitoring and therefore does not constitute an effective compliance program, which gets corporations in trouble. If you try to honor your promises of confidentiality, then you're not disclosing all pertinent information and you're not cooperating. Strictly adhering to programs of organizational due process is a failure to accept responsibility, and you're sheltering culpable employees. If you advance their attorney's fees, you refuse to sanction those who want to assert their constitutional rights or are advised by their own counsel not to cooperate. And it also punishes it pressures corporations to behave unethically towards their employees. An effective compliance program requires intense monitoring. I can't tell you exactly what it is. I can tell you that Deloitte & Touche now offers a service to corporations in which it will come in and create complete psychological profiles of their employees, including their marital status, their recreational type of activities, in order to help them identify those who are more likely to break rules. It requires corporations to encourage whistleblowing with promises of confidentiality, such as the employee hotline, which it must then break by revealing the information to the prosecutors to help the prosecutors come after the employees. It requires corporations to adopt a presumption of guilt rather than innocence for their employees by accepting responsibility. Corporate counsel's got to protect the corporation, not the employees. If the only way to protect the corporation is to sacrifice the employees, corporations who are looking out for the shareholders' bottom line are under pressure to do exactly that. And the other thing is that this policy discourages ethical audits, because any information revealed by an ethical audit must be disclosed. There's no selective waiver. You waived attorney-client privilege. You're turning over the information not just to the prosecutors, but to every plaintiff's attorney that wants to sue the corporation. And once you do this, all you can do is settle. So it's better not to know. My time's just about up. These are some of the problems associated with the current way in which we're trying to enforce these policies. What I want to recommend is, if the goal is truly to reduce rule breaking by employees, if the goal or the purpose of corporate criminal punishment is more effective reduction in white-collar behavior, then our policy should be radically changed. And what we would want to do is have law enforcement policies that not only permit, but encourage corporations to adopt the more effective way of reducing lawbreaking, which would be the procedural justice approach.
Thank you, John. Our next